I would like to know your thoughts on this one. Do you think they did right by getting rid of him, or do you think he should have been allowed to keep his job? If you would like to read the full judgment, a link will be in the description. In the Queen's Bench Division. Regina, Ali, v. Police Appeals Tribunal. While he was a student police officer, the claimant faced allegations that in the course of his studies he had deliberately and knowingly submitted as his own the work of another student officer which he had copied, and that conduct was misleading and dishonest, breaching the standards of professional behavior which applied to him pursuant to Schedule 2 to the Police Conduct Regulations 2012 and amounting to gross misconduct. A meeting was convened with his supervisor and the lead internal quality assessor for the study program in order to discuss the similarities of his work to that of another student officer. Following that meeting, a notice was issued to the claimant under Regulation 15 of the 2012 Regulations of an investigation into his alleged misconduct. In addition to the original allegation, a further allegation was added that, in the course of the meeting, the claimant had stated that the work was his own and that he could not understand or explain why areas of his work were identical to hers or remember whether he had given to or received work from anyone else, which conduct was itself misleading and dishonest and amounted to gross misconduct. At the subsequent misconduct hearing, the claimant applied to dismiss the new allegation on the basis that the failure to serve a Regulation 15 notice before the earlier meeting was a departure from the 2012 regulations which had caused irredeemable prejudice to him, as the internal quality assessor had, by holding that meeting, in effect conducted a de facto misconduct investigation. The panel determined the application as a preliminary matter, rejected it, and proceeded to dismiss the claimant for gross misconduct. The claimant's appeal to the chair of the Police Appeals Tribunal was dismissed as having no real prospect of success. On the claimant's claim for judicial review of the chair's decision, held, claim dismissed. While the Police Conduct Regulations 2012 provided important safeguards and protections for police officers by imposing a duty to serve a Regulation 15 notice as soon as reasonably practicable, there was nothing on the face of the 2012 regulations, or identifiable by reference to their purpose, which excluded as being unlawful and incompatible with the regulations an informal factual inquiry preceding the Regulation 15 notice in an appropriate case. Such an inquiry did not, in and of itself, undermine the safeguards of the Regulation 15 notice mechanism and might be justified where, for example, it was required to determine whether a matter fell to be characterized as a mere performance issue rather than potential misconduct, or to ask questions of officers to establish basic facts without proceeding immediately to a formal assessment. Such matters might engage a good faith exercise of judgment. It followed that whether non-service of a Regulation 15 notice constituted a regulatory departure was a context-specific question which called for the evaluation of a specialist panel. In this case, where the panel had had the benefit of viewing contemporaneous documents and hearing evidence from 3 witnesses, who had been cross-examined and found to be credible, it had been entitled to conclude that when the internal quality assessor had sought the initial meeting, she had genuinely held a view that this was a performance issue for which there might have been an innocent explanation. The panel had given a fully reasoned judgment in which, having expressly evaluated whether the informal meeting had been a de facto misconduct investigation and whether a formal process ought to have been invoked at that point or when the issue first came to light, it had concluded that the formal procedure had not been, nor ought it to have been, engaged at or before the initial meeting, and that there had therefore been no regulatory departure. Where the findings of fact had been clear and an appeal would not have entailed or necessitated any further live evidence of fact, it had been open to the chair of the appeal tribunal to conclude that that element of the claimant's appeal had no realistic prospect of success. That determination was not unreasonable, illogical or inadequately reasoned, para 21.